There is a quiet, devastating gap between people who argue and people who win arguments. Most people argue, very few people win, and the difference has almost nothing to do with intelligence, volume, or passion. It has everything to do with structure, with the disciplined, methodical architecture of a well-built argument. I have spent my career in courtrooms watching brilliant people lose and watching ordinary people win, and the single most reliable predictor of victory is not the strength of someone's conviction, it is the clarity of their reasoning. Let me tell you something that took me years in courtrooms to fully appreciate. An argument, properly constructed, is one of the most powerful instruments a human being can wield. It is more persuasive than anger. It is more durable than charm. It is more effective than rank, status, or brute force. A properly built argument, assembled with care, delivered with discipline, can stop a corporation in its tracks, reverse a government decision, or free an innocent man. I have seen it happen. I have been privileged enough to make it happen. And what I want you to understand, with complete seriousness, is that the skill behind those moments is learnable. It is not magic, it is method. The method has a name. In law school, students learn to argue using a framework called CRAC, conclusion, rule, analysis, conclusion. It is elegant in its simplicity and devastating in its effectiveness. It is the internal architecture of virtually every winning legal brief, every persuasive oral argument, every successful negotiation I have ever witnessed or participated in, and it is not exclusively a legal tool, it is a human tool, applicable at the kitchen table, in the boardroom before a judge, and in every corridor of power where decisions get made. Once you understand it, truly understand it, you will never unsee it. You will look back on arguments you have lost and you will recognize with painful clarity exactly where and why they fell apart. Before we discuss how to win arguments, we need to be honest about why most people lose them. Not because the truth was against them, but because they never gave the truth a fighting chance. The most common mistake is starting in the middle. People feel the urgency of a dispute and they leap directly into their analysis, into the why I'm right portion of the argument, before they have established any foundation for that analysis to rest upon. They begin defending a position they haven't clearly stated, citing facts that have no organizing principle, expecting their opponent to follow logic that has no starting point. The result is predictable: confusion, frustration, escalation, and ultimately defeat. Not because the facts were wrong, but because the argument was assembled incorrectly, like a building constructed from the second floor up with nothing underneath it. There is a second mistake, equally common and equally fatal: the failure to identify and state the governing rule. In law, the rule is a statute, a regulation, a precedent, something external, authoritative, and neutral. But rules don't only live in law books. Rules live in company policy manuals, in homeowners association bylaws, in contractual agreements, in medical protocols, in the terms and conditions of every relationship and institution that governs our daily lives. The rule is the foundation upon which every legitimate argument rests. When you don't state the rule, when you argue purely from opinion or emotion, you have no foundation. Your opponent can say, "Well, I see it differently." And there is nothing you can point to that anchors your position in something beyond personal preference. Without the rule, the argument dissolves into a quarrel, and quarrels are not won, they are merely survived. The third mistake is the most tragic, because it is the mistake of people who actually have strong arguments but lose them anyway. These are people who abandon the logical structure of their argument the moment they feel challenged. They had a good conclusion, they had a solid rule, they had compelling facts, but the moment their opponent pushed back, with emotion, with aggression, with a raised voice, or a dismissive wave of the hand, they abandoned the structure and descended into the chaos of quarreling. They let the fight become about feelings rather than facts, and in doing so, they surrendered every advantage the structure had given them. These three mistakes are not inevitable. They are habits, and habits can be replaced. Let us take the framework apart, piece by piece, so that you understand not just what it is, but why it works, because understanding the why is what transforms a technique into an instinct. Every argument begins with a statement of position, not a question, not a hedge, not a tentative suggestion offered apologetically, with one foot already out the door. A statement, clear, direct, and unambiguous. This is your conclusion, stated up front, before the evidence, before the analysis, before anything else. I have stood before judges and juries and justices of the Supreme Court of the United States, and I have always led with the conclusion. Not because it is dramatic, though it can be, but because it is efficient. It tells the listener exactly where we are going before we begin the journey. It respects their intelligence and their time, and it signals unmistakably that you know what you are talking about. State your conclusion simply. State it plainly. Resist the temptation to soften it or qualify it into ambiguity. The first words out of your mouth in any argument frame everything that follows. Having stated your conclusion, you must immediately establish the rule upon which your argument rests. This is the single most important strategic step in the entire framework, and it is the one most consistently overlooked by people who argue outside the legal profession. The rule is not your opinion. The rule is not your preference. The rule is an external, authoritative standard, something that exists independently of you, independently of your opponent, and independently of the outcome you each desire. When you identify and state the rule correctly, you accomplish something extraordinary. You move the argument out of the realm of subjective dispute and into the realm of objective application. You are no longer asking your opponent to agree with your viewpoint. You are asking them to acknowledge a standard that was established before either of you walked into the room. This is enormously powerful. Think about what happens psychologically when you cite a rule. Your opponent can no longer simply counter with, "Well, I disagree," because the disagreement is no longer with you. It is with the rule. And rules, statutes, regulations, established precedents, written policies, signed contracts carry an authority that personal opinion never can. When someone disagrees with the rule rather than with you, they have revealed the weakness of their position. They are no longer arguing on legitimate grounds. They are arguing against the established framework itself, and most intelligent people, in most contexts, are not willing to do that openly. Find the rule that governs your situation, read it carefully, state it completely and accurately, not just the part that favors you, but the full, fair statement of it. Intellectual honesty at this stage is not generosity to your opponent, it is a tactical necessity. If you selectively state the rule and your opponent catches it, your credibility collapses and your argument collapses with it. State the rule fully, accurately, and with confidence. Let it stand on its own authority. Now, and only now, do you build your argument. You have stated where you stand. You have established the rule. Now you apply the facts of your specific situation to that rule, and you demonstrate methodically and thoroughly that the facts support your conclusion. This is where most people think the argument begins. They are wrong. It begins here, yes, but only because you have built the architecture that makes this step effective. The analysis without the preceding steps is an orphan. Strong perhaps in isolation, but disconnected, unsupported, and ultimately unconvincing. The analysis with the preceding steps is a logical inevitability. You are not asking anyone to trust you. You are showing them that the conclusion follows necessarily from the rule and the facts, the way a mathematical proof follows necessarily from its axioms. Be thorough in your analysis. Do not skip steps because they seem obvious to you. They may not be obvious to your audience. Do not assume your listener shares your background knowledge or your interpretation of the facts. Walk through the analysis as if you are explaining it to someone intelligent but unfamiliar with the specifics of your situation. This is not condescension, this is clarity, and clarity is the most underrated virtue in argument. I have seen cases turn on this single technique. An attorney stands up and says, "The opposing side will argue X," and that would be a reasonable argument, if not for the fact that the rule expressly provides Y, and the evidence in this case clearly shows Z. In that moment, the other side's entire line of attack has been neutralized before it was even launched. That is the power of thorough analysis. Use evidence. Use specific facts, specific dates, specific figures. Evidence is the currency of the argument. Assertions without evidence are merely opinions, and opinions, no matter how sincerely held, do not win arguments. Facts do, documents do, witnesses do. The specific, concrete, verifiable details of your situation, laid against the standard of the rule, are what transform a position into a proof. When you have stated your conclusion, established your rule, and built your analysis, you return to your conclusion, restated, now with the full weight of everything you have demonstrated behind it. This is not repetition for its own sake. This is the closing of the logical circle. You began by telling your audience where you were going. You have now taken them there. The final conclusion reminds them of the destination and confirms that you have arrived. The final conclusion should be delivered with quiet certainty, not with triumph. Triumph is alienating, and you may need to continue working with or living alongside the person you are arguing with. Not with aggression. Aggression signals that you do not trust the strength of your argument to do the work. With quiet, steady, unshakable certainty. The certainty of someone who knows, beyond reasonable doubt, that the logic compels the result. Let me show you what this looks like in practice, because a framework that only works in a courtroom is a framework of limited value. The true measure of CRAC is that it functions everywhere human beings find themselves in dispute, which is everywhere. In the workplace, you walk into work one morning, 5 minutes after your scheduled start time. Your supervisor confronts you in front of your colleagues, voice raised, threatening disciplinary action, and making implications about your future with the company. Your instinct, most people's instinct, is to respond in kind, to say, "I'm not late," with emphasis and frustration, and the implicit expectation that the emotional conviction of your denial will somehow carry the argument. It will not. Your supervisor's emotional conviction that you are late is equally strong. You will both simply be two people who feel strongly about opposite things, and the person with more institutional power will win. Not because they were right, but because power, in the absence of structure, fills the vacuum. Use the structure. Tell your supervisor clearly, without defensiveness, without aggression, without apology, you are not actually late. That is your conclusion. The company's policy manual, the rule, defines lateness as arriving 10 minutes or more after the scheduled start of a shift. That is not your interpretation. That is the written standard. The analysis, you arrive 5 minutes after your shift began, not 10 minutes or more. You are therefore, by the express definition of the policy, not late. The final conclusion, because you are not late by the definition established in the policy, there is no basis for disciplinary action, and you would respectfully request that this matter be closed. Notice what has happened. You have not argued in the colloquial sense of the word. You have not raised your voice or traded accusations. You have simply presented an airtight logical structure. And your supervisor, if they are a reasonable person operating in good faith, has nowhere to go. The rule is not yours. It belongs to the company. The facts are not disputed. You arrive 5 minutes after your shift, not 10. The conclusion follows necessarily. The argument is over before it truly began. This is the quiet power of structured argumentation. It doesn't feel like fighting because it isn't fighting. It is the systematic and disciplined application of logic to disputed facts in a court of law. Now let me show you what this looks like in a legal context, because nothing illustrates the full power of structured argument more clearly than the courtroom, where the stakes are highest and the standards are most exacting. Suppose you have been served with a lawsuit demanding payment on a credit card debt. The account has not been used in a decade. You don't dispute that you once owed the money, but you know, or you have reason to believe, that something about the timing of this lawsuit might be legally significant. In Texas, as in many jurisdictions, contract disputes must be filed within 4 years of the breach. This is called the statute of limitations, and it exists not as a technicality, but as a considered policy judgment, that after sufficient time has passed, the difficulty of fairly resolving disputes outweighs the benefit of forcing defendants to answer for stale claims. When you stand before that judge, you do not begin by pleading your hardships, or explaining the complicated history of the account, or asking for sympathy. You begin with your conclusion. The plaintiff cannot sue you for this debt, and the case must be dismissed. You state the rule. Texas law requires that breach of contract lawsuits be filed within 4 years of the breach. Any lawsuit filed outside that window is barred by law. You build your analysis. The last use of the account, and therefore the date of the breach, occurred in 2013. The plaintiff did not file this lawsuit until 2023. 10 years elapsed between the breach and the filing, which is more than twice the permissible limitations period. The final conclusion? Because the plaintiff failed to file within the 4-year limitations period, the lawsuit is barred by law and must be dismissed in your favor. When a judge hears an argument structured this way, conclusion, rule, analysis, conclusion, something significant happens. The judge recognizes the framework. The judge has been speaking this language, living in this logical universe, for their entire professional life. And when they hear it spoken back to them with clarity and precision, especially by someone who is not an attorney, the effect is profound. You have demonstrated that you understand not just what you want, but why the law requires that you receive it. That is a fundamentally different kind of claim, and it is received accordingly. I want to be direct about something. This is not a loophole. The statute of limitations is not a trick. It is a law. It was enacted by a legislature representing the people of Texas. It carries the full force of legal authority. Invoking it is not gaming the system. It is the system. And knowing how to invoke it, knowing how to present it to a judge in the language the law recognizes and respects, is the difference between a claim that succeeds and a claim that fails. I want to address something that the textbook treatment of argumentation often glosses over, because in my experience, it is where more arguments are lost than anywhere else. You can construct a perfect argument. You can state your conclusion with precision, establish the rule with accuracy, build your analysis with care, and reach your final conclusion with authority. And sometimes, Often, your opponent will respond not by engaging with the structure of your argument, but by attacking you, by raising their voice, by questioning your motives or your intelligence or your character, by introducing irrelevant grievances, by generally attempting to convert the structured argument into an unstructured brawl where logic no longer governs and where the person with the most emotional endurance or the most social power wins. This is the decisive moment of every argument, and most people lose it. They lose it because they are human, and because humans respond to aggression instinctively rather than strategically. When someone attacks, the instinct is to defend or counterattack. Either move is a mistake. Defending pulls you off the structure. Suddenly you are talking about your motives or your character rather than the rule and the facts. Counterattacking is worse. You have now descended to their level and conceded that the rules of engagement have shifted from logic to combat. Here is what I have learned over decades of some of the most high-stakes arguments that American law has produced. The moment your opponent abandons logic for aggression, you have won. The only thing left to do is not lose the victory. Don't follow them into the mud. There is an old expression, I have always found it precisely accurate, that says you should never wrestle with a pig. You will both get dirty, and the pig will enjoy it. The aggression you are witnessing is not strength. It is the absence of a valid response. When someone has a strong argument, they make the argument. When they don't, they attack the arguer. The attack is a concession. Recognize it as such. Take your win and walk away. Not with triumphalism, with dignity. I want to close with something that I think is more important than the framework itself, because the framework without the principle is a technique, and techniques can be misused. The word argue comes from a Latin root meaning to make clear. Arguere, to clarify, to illuminate, to make plain. To argue, in the truest sense, is not to fight, it is to reason. It is to lay out the grounds for a position so completely and transparently that another person can follow your logic from its premises to its conclusion. Real argument is a form of respect. It is the decision to engage with another person's intelligence rather than simply to overwhelm their will. What most people call arguing, the raised voices, the insults, the circular recriminations, the bitter quarreling, is not argument at all. It is the failure of argument. It is what happens when neither party has the discipline or the skill to structure their position, so they substitute volume for logic and aggression for evidence. You have seen it. You have probably participated in it. And in the cold aftermath of those exchanges, you have probably felt what most people feel. Exhausted, frustrated, and no closer to resolution than when it began. Real argument is different. Real argument has a beginning, a middle, and an end. It proceeds logically from a stated position through an established standard to a reasoned conclusion. It deals in facts rather than feelings, not because feelings don't matter, but because feelings are not transferable. I cannot give you my conviction. I cannot make you feel what I feel, but I can give you the facts. I can show you the rule. I can walk you through the analysis until the conclusion is no longer a matter of opinion but a matter of logic. This is why law, genuine law, practiced with integrity, is one of the most important institutions in human civilization. Not because lawyers are particularly virtuous, we are not always, but because the legal framework, at its best, provides a structured, rule-governed process for resolving disputes without resort to power or violence. It takes the most contentious, bitter, high-stakes disagreements in human life, who owns the land, who bears responsibility for the injury, who violated whose rights, and it asks, what does the rule say, and what do the facts show, and what conclusion follows necessarily from the rule applied to the facts. That process, that discipline, that commitment to logic over power. It is not just a professional method, it is a civic virtue, and it is available to every person willing to learn it. Before I leave you with the framework, let me give you the practical guidance that makes the difference between understanding CRAC intellectually and using it effectively. Prepare before you argue. The single biggest advantage you can give yourself in any argument is preparation. Know your conclusion before the conversation begins. Identify the rule that governs the situation. Find it in writing if it exists in writing, and read it carefully enough to state it accurately. Gather the facts that support your analysis. Anticipate the counter-arguments and think through your responses to them. An argument entered with preparation is like a trial entered with a prepared case. The outcome is not guaranteed, but your chances are dramatically improved. Be precise about the rule. Vagueness is your enemy. If the rule is a written policy, quote it. Not paraphrased, but accurately. The precision of the statement matters enormously because it is the precision that gives the rule its authority. A vague recollection of what the policy says is an invitation to dispute. An accurate quotation is a fact. Keep your emotions in their proper place. I am not advising you to argue without passion. Passion is appropriate. I have argued with great passion for causes I believed in deeply, and I would do so again. But passion is most effective when it rides on top of a logical structure, not when it substitutes for one. Let the logic carry the argument. Let the passion carry the delivery. Never let the passion carry the argument by itself, because the moment it does, you have lost the structural advantage that gives you your best chance of winning. Speak plainly. The most sophisticated legal arguments I have ever made have been in plain language. Not simple. The ideas were complex, but plain. Accessible. Clear enough that a person unfamiliar with the law could follow every step. Complexity of language is often a disguise for weakness of argument. If you cannot explain your position plainly, examine whether your position is as strong as you believe it is. Know when to stop. An argument, properly concluded, should end. Not every discussion needs to continue until one party is completely demolished or fully converted. Make your argument. Make it well. If you are in a context where a decision will be made by a judge, by a supervisor, by a governing body, you have done your job. The decision is not yours to make. The argument is. If you are in a context where you are trying to persuade a peer or a family member, recognize that persuasion sometimes works slowly and that continuing to argue past the point where the other person has stopped listening does not advance your cause. I want you to sit with the implications of this for a moment, because they are broader than they might initially appear. If you internalize this framework, not just as a technique but as a way of thinking, you will find that it changes how you listen to other people's arguments as well. You will begin to notice with almost uncomfortable clarity when an argument has no stated conclusion, when it is built on no rule, when the analysis is a series of assertions without evidence. You will notice when people are quarreling instead of arguing. You will notice when aggression is being substituted for logic, and you will notice it not with contempt, because most people have never been taught any differently, but with the quiet confidence of someone who knows a better way. Here is where I leave you, with the same structure I have used throughout. Most people argue. Few people win. The difference is structure. The CRAC framework, conclusion, rule, analysis, conclusion, is the architecture of winning arguments. It is taught in law schools because it works in courtrooms. But it works in courtrooms because it works everywhere. It works in the boardroom and the bedroom, at the kitchen table and the conference table, in the hallways of power, and in the daily disputes of ordinary life. State your position clearly. Find the rule. Apply the facts. Reach the conclusion. Do it calmly, with precision, and with the unshakable confidence that comes not from arrogance, but from preparation and logic. You have now been given something that law students pay enormous amounts of money and years of their lives to learn. Not the whole of legal education. That is a different undertaking and a worthy one. But the core method, the framework that underlies every winning argument, every persuasive brief, every oral argument that has changed a judge's mind or a jury's verdict. I believe you will. Not because I know you, I don't, but because the fact that you have come this far, that you have sat with these ideas long enough to reach this sentence, tells me something about who you are. You are someone who wants to do this right, someone who understands that winning an argument and having a loud argument are two entirely different things. Someone who is willing to do the work. That is exactly the kind of person who wins.